going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday. We made it. End of another week. Hope everyone had a good week. Hope you guys have a great weekend. All right. First thing I want to say is I was supposed to have a special guest tonight. He unfortunately did have to cancel for health reasons. And yeah, so it's fine. It's fine. We'll just rock it by ourselves, right? We're used to that. The video I was going to play with him, though, I am saving it for when he does have a chance to jump on. So, yeah, no landlord tenant case tonight. So we're going to Kansas. Yeah, Judge Ricke and Miss Gillette. Not happy with tuxedo t-shirt defendant. Okay. During this, Miss Gillette does say that he's a streamer or he does some kind of streaming. I tried to find who this guy was. I couldn't find it. Maybe you guys can. You can help me out because I want to figure out who this guy is. All right, I'm rambling. You guys are awesome. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
A brief internet services interruption. The Walker matter resumes. Mr. Walker, Mr. House, Ms. Gillette appearing as before. Hopefully we won't have any more technological problems during this Zoom pretrial conference. All right. Currently before the court is a motion to dismiss counts 3 and 4 of the second amended complaint and information. What is the state's response to the motion to dismiss count 3, Ms. Gillette?
Your Honor, Deputy Bliss and Deputy Watts, what records have been provided to the defense?
Okay, that's not what that one is about.
Count 3 is battery on law enforcement officer Amy Bliss. Count 4 is aggravated battery on law enforcement officer Eric Watts. The defense wants additional medical records on these two officers, but they have been leaking the medical records of the officers to media personas and press, violating their HIPAA rights and their privacy rights. The state has motioned for a seal of confidentiality and in order for them to not disseminate any further records or for them to have to come and view them in person with the state.
Ms. Gillette, I want to go back to paragraph 2 of the motion to dismiss, which creates a totally separate and independent reason for dismissal of count 3. I'm not aware that the last charging document is the second amended complaint.
Yeah, he's doing better. He was back at work today. It was Judge Slavin. I feel like I can say that. He was going to hop on tonight. we will reschedule it hopefully next week. And maybe this weekend. I haven't talked to him yet today, but I talked to him a little yesterday. But he was at work today, and he did have a soft sit this morning. I put that video out this morning. It was a good one. He actually finished the sentence of a soft sit. It was hilarious. All right, let's keep going.
Mm-hmm.
Mr. House has raised an issue regarding essentially the severity level that that crime charges. And first of all, I wanted your response to that.
I believe it should be a misdemeanor. I think when it was amended that it got changed to felony and it should be misdemeanor.
Now, when I was making the thumbnail and I said something about the tuxedo t-shirt, can we call this a tuxedo t-shirt when it's not really a tuxedo? It's like a suit t-shirt, right? I guess we can't see it all. You can have a tuxedo and hold on. Can you have a regular tie with a tuxedo, or does it have to be a bow tie? I feel like you can still have a regular tie. Maybe that is still a tuxedo t-shirt. Okay, I am focusing way too much on the tuxedo t-shirt. All right, let's keep going.
All right. So, according to Mr. House, and I think it's an accurate statement, battery of a law enforcement officer is alleged in count 3 as a Class A misdemeanor, not a severity level 5 person felony. He moves for dismissal, but I think that at this juncture, the proper remedy is amendment of the complaint, an ordered amendment of the complaint to reflect that count 3, battery on a law enforcement officer involving Amy Bliss, is to be charged from this point forward as a Class A misdemeanor. The court will order amendment of the complaint accordingly. And it would appear then that the state is conceding on this point. All right, then back to count 4 then, which is where Ms. Gillette's argument began. This court had ordered back in March for the state to disclose and turn over doctors' records on the alleged victim's back injuries, which apparently was the impetus for the amendment to a level 5 person felony. Yet Mr. House suggests that those records haven't been turned over. Is that correct, Mr. House?
Your Honor, that's right. As to records from the state of California, we addressed that in our motion for continuance and pointed out that we hadn't received those records. That was one of the reasons we were asking for a continuance of the jury trial, so that we might have those records from California to have. We had an expert in Tulsa who was going to look at those and give us his opinion on the records. But I've talked with Ms. Gillette about it. I know she's had trouble getting those, but we still don't have them, and I don't think she has them.
I have, but
Okay.
Mr. Watts's medical records have been leaked to the public.
Okay. If he doesn't have them yet, how can he leak them?
They have had an MRI of Deputy Watts from the beginning of this case, and the defendant has shared all of his discovery.
Mr. Walker, I don't need your head shaking. Just let your attorney speak for you.
These records have, the MRI has been leaked along with other stuff to online media personas. The defendant has encouraged them to go out and find the videos of the court that are on.
Yes, no. I think you have seen this before. Giant shout out to No. I was waiting until you got here to shout you out. He's the one who let me know that this was going on yesterday. This happened while I was hanging out with Jen Hardy. So, yeah, he let me know this was going on, and I reached out to Lone Wolf, and he grabbed it for me. So thank you so much to both of them. No for letting me know what was happening, and Lone Wolf for grabbing it. So no, thank you. You might get another shout out from Lone Wolf. I think he might be using this as well. I don't know. I think he said he might. I don't know if he said he would. Anyways, let's keep going. Oh no, membership milestone first. Lizette, thank you so much for the 6 months, half a year. That is awesome. Thank you so much, Lizette. I appreciate it. Okay, now let's keep going.
On YouTube, such as today, where they made a public announcement wanting everyone to watch and make comments on it. The live stream for today. It is running rampant with death threats against everyone, but more importantly, they have leaked information about Deputy Watts's history past. These media personas are trying to go into detail about anything from former Deputy Watts's history of his medical care, trying to obtain it, talk about it. The MRI is being discussed on public YouTube streaming by these media personas that have been leaked by the defendant and his people that are working with him. They have been harassing, following the deputies. It's not appropriate. The leaking of his personal medical MRI to these individuals who are discussing it publicly live on YouTube videos to get likes and hate messages and stuff out there is not appropriate. That is protected healthcare information for Deputy Watts that are required to be turned over. The discussions of his herniated discs, his physical therapy, all of the stuff that would be contained in his protected healthcare information should not be being leaked out to these media personas who are discussing it in detail, even going back to his records in Arizona and discussing whether or not he had medical things in Arizona is being discussed, or where he has previously lived, trying to obtain his medical history based on the information that they have gotten off of the discovery that's already been given. The leaking of this discovery has been egregious by the defendant. He has allowed this deputy's medical records to go onto live streams. That's not appropriate to the victim in this matter. Whether the victim is a law enforcement officer or not is immaterial to his privacy of his medical records, except for within the jury trial where they may have to be introduced into evidence. But pre-trial leaking of his personal information, including the things that would contain his personal identifiers, is not okay. And at this point, what I have.
All right. I think this needs to be said. What he did, what this guy did, it's not okay. Miss Gillette's right. It is not okay, which is why I love my community. You guys are awesome. We watch this stuff, or we watch the court cases. We're not out there trying to make people have a, worse day than they're already having. Like, that's not okay. We all know this. Bad defendant. Bad defendant. Kathy Berry, thank you so much for your 6 months. That is awesome. 2 in a row, a happy year. That's awesome. And for the 5 gifted memberships, thank you so much, Kathy. And welcome to the 5 new members. All right, let's keep going.
In my possession needs to be looked at under a sealed camera. If it has to be given to an expert, an order protecting that has to be done. I talked with Mr. House and told him that I would be filing this motion because of everything that's been going on and the harassment and the more recent posts that have been going on. This stuff has amped up in the last 2 weeks with live streaming in the courthouse, harassment of witnesses and trying to intimidate people, including the state. No, that is not okay. And Mr. Watts, former Deputy Watts, his healthcare information needs to be protected. If an expert wants to look at it, the expert could have it to look at under seal to not be disclosed further, but I do not believe this defendant needs to have it in his hands. And if Mr. House is given it, he should never disseminate it further to the defendant because of the actions of the defendant. He has created a new Facebook group within the last week and has been posting all kinds of slanderous stuff on there that is not true. And there needs to be a seal on any further record disclosure of Deputy Watts or Amy Bliss's medical information before it's turned over, because this has gone rampant and is not appropriate.
All right, Mr. Let me stop you there.
Absolutely, he is, Doc Ock. And, if this guy's a streamer, I'm sure that this is all for show. He did that for a show. And, yeah. I'm not a big fan of this guy. I don't think any of us are. I mean, I'm a fan of Miss Gillette, and this is the second defendant I've seen her, actually worried about her safety with. I don't think she said that yet. That's coming up, but yeah.
Some medical information regarding the injuries to one or more of these alleged victims has already been provided to the defense, correct?
Yes.
Including some MRI results on Eric Watts, correct? Okay. What is still coming from California, which is relevant?
The consultation with the neurospinal expert that Mr. Watts had to go to in California, the order for his physical therapy he is having to do for the ruptured disc, the all of the information as to what the specialist out of California has said has to happen with former Deputy Watts from here into the future. So that information should be protected for.
All right. How long have you had it?
I got some of it a while back. I got some of it this last week because we had to end up actually having a second set of releases signed. Former Deputy Watts has signed several releases and sent them, requesting them. He's made several calls to California to try to get them. I finally had to also intervene and make requests from my offices with copies of the authorizations to get even more records. He's been willing to turn over anything in his possession from the beginning. And so that information has been available, but with the dissemination of his health care, the harassment he's been under, he doesn't feel safe releasing anything else to the defendant.
MB, thank you so much for the PayPal. That was generous of you. Thank you. I appreciate it. And I am going to use that to upgrade flowers for my daughters. It was one of my daughter's birthday today. The other one's birthday was last week, and they were supposed to have a swim meet tomorrow that was canceled due to the recent hurricane down there. So I was sending them flowers to try to, make them smile, because one of my daughters is really upset about the swim meet being canceled. So MB, thank you so much. I appreciate it.
All right. So I trust that the records were released to Mr. House in documentary form, correct? On paper?
He has the MRI on paper. The report from the MRI on paper. The stuff that is out of California, he does not have yet.
Now, all right. I'm not talking about California. I'm talking about what Mr. House has already been provided.
Yes, it's been in paper.
All right. Mr. House, did you actually give that to your client?
The only thing I've given to my client is discovery that was provided to me by the county attorney. Videos of the incident that were taken, and I did give that to them to take it home and look at it. And the reason that we're asking for these records.
Okay, wait a minute. One thing at a time. I'm wanting to know what you gave your client. Did you give him some of this alleged victim's medical records?
No.
No, I did not.
Then how did they get out into the public domain?
I have no idea, Judge.
They haven't.
So you're telling me, Mr. House, as an officer of the court, that you did not provide copies of these materials when you received them to anyone else, including your own client?
I provided my clients the videos that were given to me, and I've provided them copies of pleadings. And
I'm narrowly focusing on medical records. I don't care about pleadings.
Okay.
I don't care about
Right.
videos right now. What I'm concerned about is some private, HIPAA-protected medical records for an alleged victim in this case, which in this court's opinion should never be turned over to a criminal defendant.
I have not.
Counsel's entitled to see them. Counsel's entitled to discuss those with his client, and even under certain circumstances would be enabled to share them, to let the client look at them, for example, in his office or conference room. But as far as ever giving him copies, that shouldn't happen. And I think that's well established. And quite frankly, Ms. Gillette would have been well within her rights to demand a protective order upon turning over those records signed by counsel that he will follow those rules. But Mr. House, you're giving me the impression that you never turned them over to Mr. Walker.
That's right.
Which again makes me wonder, why are they in the public domain? Who did turn them over then?
No.
I don't know. I haven't seen them.
Well, first of all, Mr. House, are you aware that these records are being discussed publicly on some sort of website or program?
Miss Gillette has informed me of the social media, so to speak, incidents recently, and I don't get involved in social media. I've told my clients that we're going to try our case in the court, not in the newspaper, not on social media, and I stand with that statement.
Yeah, you're pretty much caught up. This guy's a streamer of sorts, and he's been making threats and discussing the case on his channel. Yeah, I don't even know what his charges are, but if the victim's a police officer and he has back issues or spine issues, I wonder if it's a car accident of sorts. I don't know, but this is a hearing to essentially admonish the defendant. I think we'll find out. This is a long one. I've always skimmed this. I haven't watched this fully, so I'm kind of watching it for the first time with you guys. Janie, so good to see you, Janie. I hope you're doing well. Thank you so much for the $3 super chat. Thank you so much. Australian dollars. I like Australian dollars. Thank you, Janie.
All right. Well, certainly, Mr. House, your track record with the court over a period of years speaks for itself. If you're telling this court that you did not turn these records over even to your client, then I'll take that at face value at this point, Mr. House. But it still makes me wonder then, from what other source could any other person outside this case access these records? I suppose it could be leaked by the county attorney's office. I would find that extraordinary, but I suppose that's a possibility. Or from the medical providers themselves, which also seems quite unlikely given their adherence to HIPAA standards. Sometimes even to ridiculous lengths, they follow HIPAA standards. All right, so, but Ms. Gillette, I need something more specific than a while back when you received these California records. Surely there's a date certain you can identify.
When Deputy Watts moved back to the area, they would have been available to me. He moved back in around April.
Yeah, I agree with that, Allie. He probably just handed him all the discovery. The defendant probably requested it. Just said, "Hey, can I have a copy of all the discovery? I want to go through it." And his defense attorney probably didn't even think twice about it. That's what I imagine happened.
He brought them in to me to copy, but he's been scared to bring them in to be copied. And so with his being scared of having them be copied and distributed further as to everything else going on, I asked him to go ahead and bring them in so that I could have them. And we did so. He had been writing to and calling the doctors in California for quite some time. So in the last several weeks, I've asked him to come in and re-sign releases with me so that I can see if I can obtain them by myself with his releases. I have copies of everything that was in his possession. The doctors in California have still not responded to my request or his requests, but I have everything that is in his possession. I would ask that if it's not that they have to come look at the records, like if they need or want an expert to look at them, that there is a non-dissemination order on anything further that is given out, any MRI records that would be in the defendant's possession or his son's possession, because I understand that his son has also had the videos of this case. And Mr. House is the person who told me that. And all of these social media presences have copies of all of these videos and have been running them on websites like crazy. That all of that has to be,
Go ahead.
all of that has to be protected and not disseminated. Any medical records in anyone's possession other than Mr. House should be destroyed. It should not be out there. It should not be further disseminated anywhere. The medical records, if I need to give them to Mr. House for his expert, should not be disseminated further than Mr. House or the expert. It needs to be under complete 100% seal. I would prefer they have to come look at them.
What are you wanting me to explain? All Ms. Gillette's saying is any copies of the medical records that are not in the discovery file that the defense attorney has need to be destroyed. That's really all she's saying. Unless you were, I mean, I get these comments 30 seconds late. So if you're talking about something else, I don't know.
Because of what's happened with all the leakage of stuff out of this case. I mean, the videos are being edited. They're being still shot. They're being put on social media daily. All of the witness statements and the affidavits are on the website. the actual victim witness statements to the disorderly conduct of the personnel of the Elk County. And we're not talking about deputies. We're talking about office staff in the other offices that are employees of Elk County have been leaked and are on the public websites. The paper documentation that Mr. House gave his client of his case to look at have all been leaked on these public websites. The victims' names and information should not be out there before trial. The copies of their statements in their handwriting should not be being posted on public websites. That shows how much of the paper documentation has been given out and not just the videos, because they're all made public right now, and you can go live on YouTube. And if I have to log in my computer and scroll up on YouTube these sites for you to watch them, we can take time to do that. Or I can send the court the links so the court can click on the links and watch these videos that
I don't
show.
want to watch the videos.
Stuff.
The only time that these videos are relevant in this court's view is when they're presented in court.
And the victim statements should not be being taken photos of or
And your position that those are protected documents comes from where?
Judge, the
You filed
evidence,
these public charges identifying these people as potential victims in the case. So it's been a matter of public record ever since you filed charges in this case that they're victims in the case.
that are made public. The evidence is the evidence that is sealed until the time of trial. If the court looks at the state's motion, especially in State v. Alston, and that's where the state was leaking evidence, not a defendant. They wanted to sanction the state for leaking evidence, including statements and affidavits. And it is said that only the public record should be distributed prior to trial. What is in victim statements, what is in affidavits, what is in video is supposed to remain confidential until the time of trial. Public information that is gleaned by a reporter in a courtroom being there publicly may be talked about from a public hearing, but the state.
She kind of pushes the line a little bit. I don't think she's in trouble with anybody. I think she, does a good job, but she does push the line a little bit. But I've seen a couple judges get a little frustrated with her. She sometimes can't hold back her frustration, and she'll have witty remarks. And she's been snapped at by Judge Webster before because of that. Julie, this guy, he's supposedly a streamer. That's kind of what this entire hearing's about, is him discussing his case on his YouTube channel. I don't know who he is, though. I have no idea.
The affidavits, copies of those documents are not to be made public until after the trial is occurred. And they're not. They're being used rampantly in State v. Huffman, the freedom of speech against the regulation. The court has to balance and weigh that. And I quote State v. Huffman. Further, I also quote the U.S. Supreme Court in Gannett Company versus DePasco, which is 433 U.S. 368, 1979, as to proceedings in the courtroom and who is allowed in and who's not allowed in, and how narrowly tailored things must be for rules on excluding people or things from the courtroom, or how to protect things. And in this case, those documents are supposed to remain as part of the sealed case until time of trial. The only thing that is public is what are public documents going back and forth in the court's public record. But the affidavit is actually sealed, and the victim statements are evidence, not public documents in the public record of the public court file that you can find on the Odyssey system, is what Kansas uses. Our eFlex filing public system is called Odyssey. What's in Odyssey is public. What's in the discovery is not. And the laws and the cases that I have cited in my motion are what shows that is not to be disclosed until after the trial. If media wants to do some kind of story on it afterward, make a movie out of a case, those documents are sealed until the trial. And the fact that they're being posted out there has allowed these social and special interest groups to have copies of this stuff, addresses of people that should have been redacted by the defense when they receive them, because we have to give the defense unredacted copies. The defendant should have redacted copies, if any. And the problem that we're running into is all of this is being posted publicly on YouTube channels daily. And I've also filed a motion to issue a temporary, and I wanted it ex parte, but I want an injunction of protective order until the final hearing and trial to maintain the status quo. At this point, almost all the evidence is out there from Mr. Walker himself messing with his own jury trial, because him and his family have been talking to, interviewed by, giving information to two social media personas that are posting everything on a YouTube channel and live streaming from the courthouse and in the county. In fact, this week, Mr. Walker's wife was talking all about this case on a live stream, called my office. He's shaking his head yes that they did, and called my office saying they thought they were afraid of deputies because they've been down here making threats towards the deputies, and now they think they're afraid of them because they've made so many threats to harm them and me. 2 weeks ago, as of yesterday, one of these social media followers called my office and asked if I was a Republican or Democrat, which my secretary said she didn't really know because she hadn't asked me, and that they wanted to break down my door, drag me out on the courthouse lawn, and string me up in a tree. That's disturbing, extremely disturbing. And that's what they told my secretary. So I have had to hire extra security to follow me around. And on the court day, I have extra security that is going to follow me around to watch my back so I can concentrate on my job, because I've had 3 death threats in 2 weeks. And the sheriff is having to bring in extra security. So part of my motion is also for additional security for the trial, which the sheriff is already trying to get in. That's
been previously addressed by court administration.
For a limit of recording by press, especially the 2 entities, because it has to be very narrowly tailored, that these 2 entities that keep putting everything on and coming to the courthouse to live stream, that they cannot live stream the jury trial, they cannot broadcast it, and they not be allowed in because they seem to like to sneak stuff in, and that they not be allowed in the courtroom. Now, if you read my full motion, I fully encourage the legal rule following press, especially our local press, that have never abused their privileges to record things, be allowed. I fully encourage the First Amendment for those who do it appropriately. But the 2 entities that are
Walker,
listed.
why do you have to keep acting up? I don't care what your opinions are along the way. If I want to know your opinion on something, Mr. Walker, I will ask you specifically. I don't need you to give me indications by the shaking of your head as to whether you approve or disapprove of what's being said. So stop it. All right. We're just jumping so far out ahead that let me address the first issue in this case. Mr. House, I will enter an order at this time precluding either the state or the defense from publicly disseminating any of the case materials in this case that are not a matter of public record already. And that would include any affidavits, witness statements, or any other materials that were gathered in discovery that are not part of a public filing that's already in a public court file. Whether you've actually been guilty of disseminating that in the past or not, I'm putting an order precluding it at this time. That same order applies to Mr. Walker. There is nothing to be gained by public dissemination of these materials. and very well may interfere with the ability of one or both parties to have a fair trial. Therefore, the records, and I realize that the cat may be out of the bag already, but from this point forward, this court will enter a specific order barring both sides from publicly disseminating these records without a prior written court order from this court. Any questions about that, Mr. House?
None, Your Honor.
Okay, Ms. Gillette, any questions?
Not about that.
Furthermore, this court has no intention of allowing any recording in the courtroom, whether it be by video, tape recording, cell phone, or any other manner. There is going to be an official record taken in the case. The court reporter obviously will have the ability to record and or take down any testimony in the particular case, but I will entrust that solely to court staff. I'm not going to pick and choose among people in the press about who can record and who can't. If this has been an issue in this case, the court's going to put a stop to it, and the court's not going to allow any recording. It is a public trial, and people will be allowed to attend and watch the trial proceedings. They may not always be allowed in the courtroom itself. If not, we will provide an appropriate closed circuit television or some other ability for them to watch. But there will be no recording of any of the trial proceedings in the case. That should address Ms. Gillette's concern in that regard. Furthermore, this court is, at least at first glance, disturbed about the state's reticence to turn over necessary discovery materials. One of the critical issues in the case that they intend to prosecute in regards to this matter is the alleged injury suffered by one officer in this case. In fact, they allege very serious injuries in the case. In the second amended information in this case, aggravated battery on a law enforcement officer, the allegation is physical contact was causing great bodily harm or disfigurement. Therefore, the medical condition of the victim is relevant, and the medical condition of the victim and the medical testimony or evidence that supports the state's claim that there was either great bodily harm or disfigurement. And I don't know, at some point you're going to have to elect whether he was disfigured or great bodily harm or some combination of the two. But the reality is, either way, there's going to need to be medical testimony in support of it. It appears that the state has had possession of these materials, knowing that they're relevant to a material issue, and has refused to turn them over to the defense. Now, I do understand Ms. Gillette's well-founded concerns. It seems to me, though, Ms. Gillette, that why didn't you just ask Mr. House, an experienced and actually quite reasonable lawyer, to sign off on a protective order addressing all of your concerns before you hand him the materials? Is there a reason why you didn't do that?
Normally it's ordered by the court.
Well, I would have likely signed off on the order that was agreed upon by counsel in the case. It would be an extraordinary situation that I wouldn't. Or you could have scheduled a motion with this court and we could have had a hearing on it. But I am disturbed about the fact that the state's sitting on important medical records, which is very material to the most serious charge pending in this case, and they haven't turned them over to the defense so that the defense can adequately prepare for this trial. Now, Mr. House at this point believes that the breach is so egregious of the prosecutor's duties that he believes it should lead to dismissal. Am I right, Mr. House?
That's what I've alleged. Now, I indicated in my motion, I've had a good working relationship with the county attorney over the years and will continue to have one. But I alleged in my motion, and she told me that she was having trouble getting these records. And I believe that. But we don't have them. We have preliminary hearing testimony that involves the alleged victim having a back problem before this ever happened. And so that's why we need to have an expert look at those new records.
All right. Well, it's obvious for this court to make a determination today, here, literally on the eve of trial, or very, very close to our trial date, that the defense would be materially compromised if these medical records were not turned over to the defense in adequate time for them to get their own expert opinion. Do you dispute that, Ms. Gillette?
I
I was confused because yeah, it's like I read the comments. There was nothing wrong. So if it, yeah, no removed his own comment. Probably because he said kind of the same thing 2 times in a row, but he put a little bit more context in the second one. That's what I'm going to assume. Right? No. But yeah. But it happens on accident sometimes where the mods just accidentally click the button. It happens.
if they need an expert to look at them, then they will need time.
I also would agree with the prosecutor in this case that these records, once turned over, are to be turned over solely to Mr. House. Mr. House would be authorized to turn those over to a retained expert for purposes of examination of those records in order for them to make an expert determination regarding the injuries allegedly suffered by this officer. These records are not to be turned over to Mr. Walker. The defense position is protected through the attorney. You may discuss the content of those records with your client privately. Those discussions are not to be disseminated to others because, quite frankly, I don't know why anyone else would need to hear it. And I think that there just needs to be very strict protocols followed in your office, Mr. House, to make sure that there's no linkage, as Ms. Gillette calls it, of these records to anyone else.
Yes, Your Honor.
Once they're turned over. Any questions about any of that, Mr. House?
No, Your Honor. I assume that the expert is a doctor in Tulsa, and I can mail those records to him, but I'll do it with the understanding that he can't share them with anyone.
That's correct. I think they would know that as a matter of course, but my order does also apply to any expert or expert agency to which these records are sent, but they are not to disseminate those to anyone else without specific authorization from this court. And I think they would know that because of their own HIPAA standards that they have to follow. But if an order is drafted from today, that it should cover the doctor or the expert agency as well. All right. The title of your motion, Ms. Gillette, ran on for about 6 sentences and covers a number of different matters. Motion for protective order, which this court has essentially granted. Non-dissemination order, which I presume is part of the protective order.
The title of her motion ran on for 6 sentences. You know, Heather was just telling me yesterday that I need to get to the point with my titles. And that it's like, she's almost the same thing. Like, no one wants to read sentences in a title. And stop putting so much text on your thumbnail. Yeah. Ms. Gillette, I feel you. I feel you on that one.
Seal certain documents. What documents need to be sealed? Sealing documents to this court is involved in records of the court. So what do we need to seal in the records of the court?
Your Honor, I submitted the exhibits of some of the things that have been being said and done that are necessary for extra security. They contain initials or last names of specific dispatchers that have been harassed in the phone logs. There are pictures of the websites of the 2 entities that are, and frankly, I don't want to say their names on the record because I don't want to give any more credence to their names, but if you want to know who they are, I will tell you.
Okay, just a minute. We're talking about sealing court records. So have you already filed these in the court?
Yes, they're filed right now, sealed, and you can make the decision to leave them sealed or unsealed.
I'm going to leave them sealed.
Okay.
I have no intention of currently unsealing any of those documents that involve these private matters.
When the medical records come into evidence during the jury trial. I would ask.
That is such a fine line, Allie, because a title kind of needs to be clickbait, right? You have to have a certain level of clickbait so people click on it. So it has to be clickbait-ish, but at the same time, you can't lie. And I think that's what a lot of people say clickbait is when you say something in a title that has nothing to do with the video. So if that's what you mean, I agree.
That the evidence in the jury trial with all medical records be made sealed so that they are not public. And if there are any requests of public for exhibits, those are sealed. They're for the jury, they're for the judge, they're for the parties. They're not for media personas to go out and make money off of.
Court is inclined to agree. Any objection to that request, Mr. House?
No, Your Honor.
All right, very well. You can include that in the order, Ms. Gillette. Temporary ex parte injunction protective order to maintain status quo. Have we covered your concerns there, Ms. Gillette?
That was that the further dissemination of any affidavits, anything like that must be destroyed. Anything that's already out there should be removed. I don't know if we can make an order to all the online personas that are using the documents that are already leaked. Any further leaking? The status quo is the way it is as of today. No further information about the evidence in this case. The videos in this case should be leaked by the defendant, as he's been leaking, because it messes with the jury trial and the ability to have a fair and impartial jury. And that is for both sides of the aisle, the defense and the state. His leaking, their commentary, it going rampant and viral, it needs to stop. And so I would ask for no further dissemination of anything in this case. The defendant.
Well, I have control over your office, Mr. House's office, and the defendant, Mr. Walker. How does my jurisdiction and authority go further than that for things that are already let out?
Yeah, I would ask that he cease. He has now started a new Facebook page, him and his wife, to try to disseminate things. You can clearly see he's posting as Bob Walker on that site over and over and over again, along with his wife. They're continuing to try to disseminate information about the case, make statements about the officers, make statements about witnesses. They've already slandered me with untruthful things on it, which opens him up to a slander suit, which is a separate civil suit that I may seek, especially since it's an election year. But that needs to stop. The further.
Oh, did you see him just get uncomfortable in his chair? Uh-oh. He's like, oh man, I didn't really think about that. I may have to stop. Oh, also, Allie, I didn't think you were saying I was clickbait. I was not at all. I was just saying, the difference in my eye, at least. Okay, let's keep going.
Slander, pulling up stuff on the officers, disseminating stuff from the case, talking about the case on all these online things. He himself is doing it. He can shake his head no earlier all he wanted to, but he himself is doing it, making the post and encouraging his wife to. So it needs to stop. To keep the status quo of where we are right now with all the leakage that's already happened, it needs to stop so that we can have a fair and impartial jury. Otherwise, I don't know how we're going to get a fair jury.
Mr. House, your response?
I technically don't object to any of that. As I said, I've always wanted to try my case in court, not out on the street or in the newspaper. I don't do social media, so, but I understand it's a problem.
Well, the court is going to enter an order precluding all parties in this case, which I think was contemplated earlier, from disseminating any further information about this case until the case has been tried and completed. I agree that there's the potential interference with being able to get an impartial jury if people are trying to try their case in social media or making comments regarding various participants in the case while this case is pending. So in essence, this is a gag order on Mr. Walker, Mr. House, and Ms. Gillette and her office from further disseminating any material or information regarding this case, with the exception of scheduling information. And speaking of that issue, there is also a motion before the court to continue this trial, which I hate to do. I would like this case reach a conclusion and be over with. But in light of the late or certainly belated turnover of the medical records, which I think reach a critical issue in this case by the state, and failing to provide that to the defense in a timely fashion, I think it's patently unrealistic to expect that the defense can be prepared for trial by next Tuesday. I will say, Mr. House, you apparently have been diligent in identifying your expert. You know where these records are eventually going to go, correct?
Yes, Your Honor.
Are you a BIDS appointed lawyer?
Yes.
Have you sought approval from BIDS for this expert?
I've not had contact with him yet.
Okay, you've identified him. All right. Well, you're going to have to act on that promptly with BIDS.
Because he's the doctor for Mrs. Walker. She has a back problem. She goes to a specialist in Tulsa, and he indicated he would be willing to look at medical reports and give his opinion.
All right. Well, I'm just saying that if you're going to be making a request to the court to approve expert services, that's
Yes.
going to need BIDS approval.
Yes.
And most likely pre-approval.
It'll have to have pre-approval from the court and bids as an extraordinary expense.
Okay. Counsel, I am on I'm in a 3-county district, as you all know. And I have various counties set for jury trial each month on rotation. Obviously, July was an Elk County month. However, the next Elk County rotation month is November. And I have that time available to assign. Tuesday, November the 5th, Mr. House. And I'm going to probably insist that counsel move whatever conflicts they have during these periods so that this trial can be accommodated. Tuesday, November 5 would be your start date. And I can set aside up to 4 days for this trial. Starting Tuesday, November 5th. Mr. House?
Yes, that's no problem with that. I have nothing on my calendar that far out.
We will conduct a formal pretrial conference again the week before. Since we have a tendency to be quite busy with our Greenwood docket on Thursdays, Ms. Gillette, do you have potential availability on Wednesday, October 30? Or Mr. House, does that cause a problem for you to be on a Wednesday?
No, we'll just schedule anything with, as long as it's not at 1:30 for first appears.
Okay.
We'll schedule around whatever you want.
Mr.
So-
House?
Another pretrial then on the 30th of
Of October.
Yes, I have no problem with that.
Okay, do you have any scheduling conflicts on your calendar already?
None that far out. September is full.
I was
And
hoping that you didn't.
vacation for 2 weeks of October, but
Okay, well, I'm looking at 10 o'clock a.m. for pretrial conference in this case. Wednesday, October the 30th. Mr. Walker,
Yep.
I'm going to order you as a condition of bond to appear in your attorney's office again. I think that works the best. Less problems potentially with technology issues, since this will be a Zoom pretrial. And then you'll have immediate access to your attorney. He'll have immediate access to you. That's what works the best. So that's what I'll order you to do. That's a Zoom proceeding you'll be in Mr. House's office Wednesday, October the 30th, 10 o'clock in the morning.
All right, thank you.
Ms. Gillette, I don't know what might come up I'm going to be liberal on scheduling on that pretrial, go far beyond what I normally do. I may just set aside a couple of hours if necessary, in case there's any pretrial motions that has arisen between now and then. I can address them. So Wednesday, October 30th, currently set from 10 to noon. Council, we don't have to take that long. Is there any chance that there might be some agreed upon disposition of this case, Ms. Gillette?
I've made an offer. The defendants refused it.
All right.
Been an offer on the table for a long time.
All right, then I see that as a big no. So we'll do pretrial conference by Zoom, October 30th at 10. Mr. House, I did want to give you an opportunity to be heard on that issue.
What's that now?
Were you going to say something about the possibilities of settlement here?
Well, it hasn't worked to this point. We just haven't been able to arrive at a settlement. So I think we're probably looking at having a jury trial.
All right.
But if things change, I will let Ms. Gillette know, and we'll proceed accordingly.
All right. Mr. Walker, I do want to give you one assurance. If you would have been in custody, and I see you're out on bond, and hopefully we will not have any issues regarding bond or your behavior on bond. If you were in custody, we wouldn't be setting it out as far as we are. But I don't think you're going to be materially compromised being a member of the community free on bond if we have to set it out as far as we've scheduled. So again, Mr. House, I don't want to have to move it again. So the sooner we can act on these medical issues. Ms. Gillette, at what point can Mr. House count on him having access to the medical records which are in your possession, what we've called the California records?
The records can be scanned in and emailed to him if we need to. I can put them in a file where he has access to them. Or if Mr. House is going to be anywhere near Elk County, we can do a paper copy for him.
I would prefer a paper set that Mr. House personally picks up from your office.
We can make a copy of them in my office, and he can pick them up anytime after today. My secretary's there right now. In fact, she's on here. So
will you be making a trip to the courthouse next week, Mr. House?
I'll be able to get up there one way or the other next week.
Okay.
All right. We still have a few minutes left of this, but what do you guys think of a bonus clip tonight? I've got one ready. It's the video that I'm releasing probably about 9 a.m. tomorrow morning. What do you guys think? Bonus clip? Or are you guys just ready to have the rest of your Friday night back? What do you think?
Appreciate that commitment, counsel. The sooner we get the records turned over to you, the sooner you're in a position to refer them to your own medical expert.
All right. Thank you, Judge.
Mr. Gillette, I will ask you to draft an order documenting the various rulings that are made here today, since primarily these were your requests.
Judge, one other request. No third-party contact. When it says no contact with victims, that should include third parties. These online personas that are acting and getting information from the defendant and his family, they have been coming down, live streaming from the courthouse or within the county, trying to call and record phone conversations with my office, the sheriff's office, calling the offices in the Elk County courthouse. They are victims of the disorderly conduct. Let me make that clear. The victims of the disorderly conduct is not Deputy Bliss. The victims are all the offices in the Elk County courthouse that expressed concern over the defendant's behavior and did not want the courthouse doors opened. Them recording in their offices, sticking phones in their faces and asking them questions, calling them Nazis, Nazi baby killers, the B word, the C word, repeatedly calling their offices over and over again till we have to hang up on them 4 and 5 times. Even one of the deputy court clerks heard how extreme he was, and calling their office repeatedly would not be appropriate. These personas are working on his behalf and in his contact. They are intimidating the witnesses, in which I am looking at charges for intimidation of witness for. that is third-party contact on his behalf. At this time, it needs to stop.
Court will certainly issue an order precluding Mr. Walker or any member of his immediate family from soliciting third parties for purposes of harassment or intimidation of witnesses in the manner in which the prosecutor describes. In other words, Mr. Walker, you're not to have third parties do what you can't do. Simple enough. Include that in the order, Ms. Gillette.
No.
As far as restricting person's behavior at the Elk County Courthouse, the Elk County Courthouse, by and large, is under the control of the commission and the individual department heads as to what their policies might be regarding access by the public or recording in their offices. That's not a matter for the court unless it involves specific district court areas. All right?
Judge,
Yes, Mr. House.
as to the motion I filed, I'm assuming since you've ordered that we continue the trial so that I and my client, or that I and the expert can review the medical records.
I'm denying your motion to dismiss that count for failure to provide those records. There's
Yes.
another remedy that the court has fashioned here that
Yes.
will ensure your client a fair trial on that count. So at this time, I'll deny your motion.
All right.
And
I understand.
obviously, the state has acquiesced in regards to your other motion regarding amendment of count 3. And I think those were essentially the matters that your motion addressed.
There was a motion to dismiss, which we can take up at the next pretrial, based on the fact that my client was not brought before a magistrate for 6 days.
Have you filed a written motion? Mr.
Yes,
House? And that's never been ruled upon?
Judge.
By the magistrate court or the district
Judge
court?
Lee decided to not rule on it and let the judge who was going to try the case rule on it.
There's a motion filed August 10th, 23. A response by the state was filed August 15th of 23.
All right.
And we don't need to take it up today, but I would.
Thank you for bringing that to the attention of the court.
All right.
All right. Very well then. Anything else, Mr. House?
No, Your Honor.
Or Ms. Gillette?
No, if you want to schedule a motion.
Could you imagine this guy getting off on a technicality after all this? That would, yeah, that'd be heartbreaking. I mean, I guess that I'm assuming he's guilty. I guess I barely even know what the charges are. So I guess I shouldn't say that. But just his actions. Yeah. All right. We don't need to watch the rest of this. They're just going through scheduling. I'll go ahead and launch the bonus clip. This video will be out tomorrow morning. And this is also thank you to Know and Know. This is from today. This is kind of funny. What's going on?
Anyway,
You do not need to see my intro. All right. As always, the DDC, the audio, you hear everything, and sometimes it sucks, but I don't think it's that big of a problem in this. Like once the defendant actually gets there.
What's your name, ma'am? That's case number 24058333401. Houston, Michigan versus Colin Stevenson. Appearances, please.
Stevenson for the people.
Judge, good morning. Philip Reagan on behalf of Ms. Stevenson. Waive the reading stamp mute. She's been advised of her rights, Judge.
Court a not guilty plea on behalf of your client. What's your bond recommendation?
See, now we can appreciate the gravity of this situation. I would be asking for remand if I could. Instead, I'm going to be asking for $150,000 cash. I'm also going to be asking for a tether as well as house arrest. This defendant has an ongoing kidnapping matter, Judge, that's up for exam next week, having to do basically with, the parties involved in it. But in this particular matter, we have a defendant who's going after the fiance of the complainant, who is strike all of that. She's going after the complainant, who's the fiance of the father that they have children in common with. And in this particular situation, the father was worried because this gal was at a house where he thought his daughter was, because that child was missing. So the police end up getting called out. She ends up leaving this residence only to come back again, and now with the knife. And she starts attacking the fiance. Now that RMS that I ended up sending to both you as well as defense counsel, at the end of it shows that there were children in the house that this individual allegedly authorized another individual to have. She's not supposed to have any interaction. I mean, she's got a kidnapping case that's going on. So if we look at the end of that RMS, it talks about kids. She has custodial issues all over the place. She has an ongoing case. Now she's got this case regarding a knife that she's brandishing, charging at the fiance of the father of the children that she's sharing with. If I could get remanded, I would. If I could.
Okay.
But I don't think kidnapping is considered a violent felony.
1 second. Mr. Reagan.
Judge, can I tell you what really happened now, Judge? Now that we've gotten all that out of the way, so she has a kidnapping case that she has been charged with. She has 3 kids with Mr. Larry Johnson. He's concerned about one of the kids and not really concerned about the other 2. So they're in the civil court. And so, Judge, I'm going to ask you, when I'm talking, I don't want a lot of other all those in the back.
Mr. Reagan,
both ways.
Mr. Reagan, gentlemen, Mr. Reagan, go ahead. I'm listening to you.
So they're in family court. So there is a order in family court now where Mr. Johnson has custody. So my client is going through the criminal part of the custodial kidnapping case. She's alleged to be innocent until proven guilty. Has an exam next week. She's tethered to her father's house. So what happens is, the complaining witness and his girlfriend come to her house where she is, trying to find out if that's where the kid is. Okay, so they come over there. My client then calls her mother. The complaining witness comes with the police. They come with the police. My client says, "Hey, the kid is not here." They ask, "Hey, can we look in the house?" He says, "No." Finally, Mr. Johnson and his fiancee leave. My client's mother comes because there are other kids that my client wants to give to her mother. Her mother pulls up to get the kids. Mr. Johnson, his fiancee, circle back around, come to the house where my client is tethered to. They get out the car, start coming at my client. My client is coming out of the house taking bags of diapers and different things to her mother, like bags for the other kids. And these individuals are harassing her. My client's mother calls the police. They then also say, "Oh, you want to call the police? We'll call the police too." They make up these lies. The video, Judge, we have video. It's going to show that my client never charged with anybody at a knife. My client never did anything like that. They're just upset because they don't yet have the daughter. My client doesn't have the daughter, Judge. And this is an ongoing thing between the father and my client. My client never pulled a knife out. She was at her place. They came to her place. She didn't go looking for them. She was tethered. She's tethered to her dad's house, Judge. These are false allegations. The video's going to show it. I just spent over an hour talking to her mother about everything that happened step by step. Who's going to be a witness in this, Judge? We're going to bring the video, and we'll drop a copy off.
All right. This gets a lot better between these two, and these two battle every day. And I really hope these two, like after work, maybe once or twice a month, go get a drink and kind of, we're not just being professionals. I really hope so, but they really get at each other sometimes, and this is no exception. Beaver, Jay Hart, during the Judge Van docket today, the knife thing just reminded me. He had a defendant who was who was confused about a charge that he had because he was like, oh, it was a kitchen knife. Like, how am I getting, dangerous weapon charge when it was a kitchen knife? That doesn't make sense. Judge Brand did his thing. The guy walked off, and Judge Brand's like, a kitchen knife? The thing was a cleaver. I mean, yeah, you can use it in the kitchen, but it was a cleaver. But it was funny. I just squirreled a little bit. Okay, let's go.
He might not be on the case at that point.
All right, last word, Mr. Vincent. Last case of the day. Make it count.
It sounds like Mr. Reagan was there from beginning to end. I mean, the way that he talks about it, he must have been there in a tree watching this whole thing. Because
Mr.
you know what?
Vincent, stay focused. Stay focused. What is your response?
Well, my ask here, Judge, is because of the custodial issue, because she's already on bond. This has already been heard. These issues have already been heard in front of the chief magistrate. He ended up giving a very high personal bond. Oh, and the knife was found. The knife that apparently that she never had, that she never ended up wielding, that was found. On top of that.
Okay.
That's
all right.
Found in her mother's.
Okay, gentlemen.
See?
Gentlemen.
Janie, thank you so much for the 5 gifted memberships. I appreciate it. And welcome to the 5 new members. That's awesome, Janie. Thank you so much. Thank you so much.
Yes, this is personal.
All right. There's a lot going on here. I'm going to give Ms. Stevenson the benefit of the doubt. $50,000 personal bond, no contact with Shanika Gill. Probable cause July 26th. Preliminary examination August 1st. Not to possess any handguns, firearms, or other dangerous weapons. Have a good day.
All right. I haven't said this in a while, and I need to bring this back, but it's about to go down.
Judge, you can't do that. She's on a personal bond. You can't give another personal bond on a personal bond. You can't do it.
Would I ask for $1 from the judge?
You can't triple stamp a double stamp. You can't triple stamp a double stamp. Anyone else get the reference?
If you ask for $1,
Okay.
It's half the time Mr. Vincent doesn't even go by that rule. He just says, "Oh, we won't go by this."
Mr. Reagan.
The court does.
Okay.
Gentlemen. So I never heard the dollar amount, sir.
Don't worry about it.
I was kind of caught in the middle of it.
No, you're good.
I did get the court date though, so.
You're good. I had to put both of them in timeout.
Oh, he most certainly did. Magistrate Burton's awesome. He is. Well, his personality and sense of humor are awesome. I don't watch him enough to know how well he does at his job, but it's fun.
Wow.
$5,000 cash surety. Is that an unaffordable bond?
That is unaffordable, Judge, from 50,000 per person.
Bond determination on Monday, July 22nd, 9 a.m. in front of Chief Judge McConico. Probable cause July 26th, preliminary examination August 1st. All right, we're finished.
Judge, can I ask how did bond go from 50,000 personal to 5,000 cash?
You can ask. All right, I'm going to let this video play out. This is the end of it. There's only about 30 seconds left. You guys are awesome. Thank you so much for hanging out. Thank you so much for watching. Thank you for the mods tonight. You guys are awesome. Thank you for the super chats. The super chats, membership milestones, gifted membership, and MB for the PayPal. I appreciate it. You guys are awesome. Let's go hang out on Discord for a little bit. Yeah. That's all I got. You guys have a great night. Have a great weekend. Tomorrow night is date night, so I will not be streaming tomorrow night. I might do a mid-afternoon stream. Generally about 50-50 on actually doing that. But I will actually have videos out. This one's going to be out tomorrow, and you know my rule. When I do the bonus clips, you don't have to rewatch the video, but please just click on it and hit the like button. I would appreciate it. All right. You guys have a great weekend. If I don't see you, don't do anything dumb. I will cover you. I promise I will. I'm not too proud. Okay. Until next time. Bye.
When did we start questioning
Gentlemen.
magistrates?
And when did you start interrupting me when I'm talking?
I didn't. I waited until you were done.
Hello, we already asked y'all to be quiet.
Okay, have a good day, everybody. We'll see you a little hour and a half, okay?